The judgment in the Democratic Alliance's application against Section 15A of the Employment Equity Act has been reserved by the High Court in Pretoria. Section 15A of the Employment Equity Act will give the Minister of Labor and Employment powers to set targets in particular employment sectors. The DA has described the new amended act as unconstitutional and unfair, arguing that this move by government is introducing racial quotas. However, the ANC rejected the DA's court application, describing it as a gimmick. ANC Gauteng Provincial Task Team, PTT, Coordinator Hope Papo has described the DA's court challenge as an insult to black people. This gimmick by the DA is an assault and affront and an insult to all black people. By black people, I mean Africans, Indian and colored. Colored people and Indian people are not only found in the Western Cape and in KZN. They are found all over the country. The act tries to deal with centuries over 500 years of colonialism and apartheid, taking over from colonialism, says Papo. What is the DA challenging? The DA is contesting Section 15A of the amended act, which empowers the Minister of Employment and Labor to set binding numerical targets for the representation of black people, women, and people with disabilities across various economic sectors. These targets apply to companies with more than 50 employees, and non-compliance could result in fines or exclusion from public contracts. The government, represented by advocate Fana Nalane SC, maintains that the act is constitutional and essential for addressing persistent inequalities stemming from apartheid. They assert that the law does not impose quotas but set sector-specific targets to promote equitable representation without compromising merit. The African National Congress, ANC, supports the legislation, emphasizing its role in correcting structural imbalances and ensuring fair opportunities for all South Africans. The DA argues that these provisions are unconstitutional, discriminatory, and economically harmful. They contend that the amendments shift the focus from flexible, employer-driven transformation to rigid, state-imposed quotas, potentially deterring investment and exacerbating unemployment. Counsel for the Department of Labor and Employment advocate Fana Nalane has argued that nothing prevents the minister from setting sectoral targets as prescribed in the Employment Equity Act. Nalane says sectoral targets have always been ingrained in the Employment Equity Act, even without the amendment. Nalane says there is nothing constitutionally impermissible with what the labor minister has done. So the concept that numerical targets have to be set and goals have to be set is something which is inherent in the pre-amendment legislation. Yes, so 15 deals with, but I'm saying in the sense of who deals with, who sets the goals. So I'm saying the principle of setting goals, numerical goals, is not something which has not been done before. The difference is that it was done by the employers, and then they would then submit their equity plans to the ministry and the department, argues Nalane. Counsel for the DA advocate Ismail Jamie has argued that the targets set out in the Employment Equity Amendment Act are vague. The DA, which is the applicant in the matter, has argued that government's Employment Equity Act is unfair and unconstitutional. Under the Act, private companies will be forced to comply with employment laws when hiring South Africans or risk a penalty. But Jamie says while the quotas set out by government must be achieved within a 5-year period by private companies, government does not set out how it should be done.